Good afternoon, students. Today is Thursday, 20 January 2022. This will be the first substantive lecture of the semester in Philosophy of Law. I hope by now you have been able to locate on Canvas, print, and read this article by Orin Kerr. All right, if you haven't, I would recommend stopping the video and going to do that. You should read the article or court opinion before you watch my video or come to class. Also, I've posted my lecture notes for this article. You should also print them and have them in front of you as you listen to my lecture. You can follow along. After all, these are my lecture notes. This is what I would be going over in class with you. Many of the exam questions will be drawn directly from the lecture notes. So it's in your interest to print them, read them carefully, and study them for the exams. Okay, let's get started. We have 2 days to discuss this article. I believe on every other item in the course, we will have 3 days, so a little bit less time, but it should be enough to cover this fairly short article. I'll try to get through about half of it today, and then on Tuesday next week, we'll finish it up. Okay, a little bit of biographical information about the author. The author is Orin Samuel Kerr. He was born on the 2nd of June, 1971. So as of today, he is 50 years old. He has a pretty sterling academic record. He attended Princeton University as an undergraduate, which is one of the Ivy League schools. And interestingly enough, given that he eventually ended up as a law professor, his major in college was mechanical and aerospace engineering. And he did very well. He received a Bachelor of Science in Engineering degree, and his degree was awarded magna cum laude, which means with big honors, with high honors. So he was a very good student at Princeton. From there, he went to Stanford University. He went across the country to another very good school, and there he earned a Master of Science degree in mechanical engineering. Now, I don't know what the story is, but evidently he was much interested in engineering and perhaps sought to make a career of it. But for whatever reason, when he got out of Stanford, he decided to go to law school. And he went to one of the very best law schools in the country, Harvard, back on the East Coast. And while at Harvard, he again was a very good student. He graduated with his law degree, magna cum laude, again with high honors. So he's very accomplished, at least in the academic world. After law school, he clerked for one of the United States Supreme Court justices, Anthony Kennedy. In fact, it's possible one day Kerr himself will be nominated to serve on the Supreme Court. He has all the credentials that one needs. He has graduation with honors from one of the best law schools in the country, and he clerked for a Supreme Court justice. Now, whether he would want to be a judge, I don't know, but all I'm saying is he has the qualifications if he should ever want to. And of course, he would need a president who would see fit to nominate him. Lots of people who are qualified to serve on the Supreme Court never get a chance to do so, as you know. So Kerr, once he finished his clerkship with Justice Kennedy, he went into law teaching. Now, he may have practiced law here and there along the way, but he's been teaching at law schools since he finished up his clerkship. He taught for a while at George Washington University Law School in Washington, D.C., and he then went back across the country to the University of Southern California School of Law. And currently, he is professor of law at UC Berkeley School of Law. That's in Berkeley, California. University of California at Berkeley. Kerr has written a great many articles and books. One of his books may be of interest to you. He wrote a book in 2006 entitled Computer Crime Law. And that book is now in at least its 4th edition. So it's turned out to be a very popular book. I'm sure it's used in law school courses around the country. He's an expert on the crimes associated with computers and the internet. Okay, the first section, you can see that Kerr divides his essay up into sections. I highlight them in yellow marker. The first section, and the only one we're going to cover today, is entitled, What's in a Legal Opinion? What's in it and why? So we're going to spend today's discussion or lecture on that topic. Now, in my notes, sometimes I quote the author. And when I do so, when I quote somebody in my lecture notes, I highlight it in yellow. Let me show you a page of my lecture notes. Now, you probably have printed these out already. I've recommended it. You can see that mine are marked up. Okay, the yellow tells me while I'm lecturing that that's a quotation from the author. It's not something I wrote, Keith. It's something that Kerr wrote. And I do that so that when I'm lecturing, I know immediately whether I'm reading something that I wrote or something that Kerr wrote, or the author of the piece. You may have noticed some green highlighting. Sometimes I quote other people besides the author. For example, a dictionary. And when I do, I highlight that in green. So that, again, tells me visually that those words are not my own, but someone else's. And they're also in quotation marks. When you quote someone, you enclose it in quotation marks. Okay, so what's in a legal opinion? Now follow along as I go. I want to begin with a quotation from Kerr, and it's the one that I had in yellow. Kerr writes on page 51, "The opinion explains what the case is about, discusses the relevant legal principles," and I put in brackets, or rules, "and then applies the law to the facts to reach a ruling in favor of one side and against the other." Okay, that's the whole quotation from Kerr. Now let's break it down, because it turns out that a legal opinion contains a number of different things. First of all, as Kerr says, the opinion explains what the case is about. Usually that's done right away. The justice writing, or judge or justice who's doing the writing, will tell the reader what the case is about in very simple terms, so that the reader right off the bat knows what kind of a case it is. Is it about a homicide? Is it about a case of drunk driving? Is it a securities matter? Is it a disagreement between two or more states? Is it about a treaty? It could be about a number of different things. So the first thing that the opinion will do is explain what the case is about. Secondly, the opinion will discuss the relevant legal principles, or perhaps rules. So the author of the opinion will state what the author takes to be the relevant principles or rules that apply in this case, and that will be used to issue a ruling. Third, once the relevant rules or principles are identified and stated, the judge or justice will apply them to the facts of the case. That's the third component. Apply the relevant principles or rules to the facts. And the result is a decision or ruling. Applying the principles to the facts results in a decision. And the decision will favor one of the parties to the case and go against the other party. Remember, in every legal case, there are two parties. They're having a conflict of some sort, and they took the case into court to help them resolve the conflict. So at the end of the day, the appellate court must resolve the conflict and tell the reader who won. Did the plaintiff win or the defendant? Now I'm using terms that I'll explain in a few minutes, plaintiff and defendant. Which party won? The court will announce that. Obviously, the winning party will be pleased, and the losing party will likely be disappointed. Okay? You have a winner and a loser in every case. Now, if it's a United States Supreme Court ruling, there's no place to appeal from there. So that would be the end of the road. And the party who is disappointed will have no further recourse, at least in the judicial system. If the case were decided at a lower federal appellate court, then the losing side could appeal. There's no guarantee that when you appeal, the higher court will take your case, but at least you have a chance to appeal and hope that the court above will take the case. So the objective of a court is to resolve a conflict. Note that the word opinion being used here differs from the everyday use of the word opinion. As you know, an opinion is like an idea or a belief. I have opinions about a great many things, as you do. Okay? That's an ordinary, everyday use of the word opinion. I may say, for example, in my opinion, the Cowboys deserve to win that game that they played this past Saturday. Okay? That's my opinion. Someone else may have a contrary opinion. But we're using the word opinion now in a precise, technical way. We're talking about legal opinions. A legal opinion is far more than a belief that someone happens to have. Also, the word opinion is related to the word opine. And if you'll look at my lecture notes on page 1, you'll see I put the dictionary definition. To opine, which is a verb, is to hold or express as an opinion. So people on television, on news shows, they are constantly opining. That means they're offering their opinions about various things. So opine is just the verb that's related to an opinion. So once again, a legal opinion, and this is me talking now, not Kerr. A legal opinion is an announcement of a belief, or perhaps, if you will, a decision or judgment, together with a statement of the grounds thereof. So a judge doesn't just announce who wins. Part of the opinion will be setting out the reasons that support that judgment, the grounds, the reasons, the rationale, okay, the basis of the judgment. It would be pointless to just announce who wins and who loses. The parties are going to wonder what was the basis of the decision. So the judge will always announce the basis of the opinion, not just the opinion. Some opinions, I can tell you, are very long. Some are quite short. The opinions we'll be reading in this course are of different lengths. We're going to begin with a hypothetical opinion or set of opinions written by Lon Fuller. That'll be our second topic. And that one goes on for quite some number of pages, more than 20 pages. Later, we'll read the case of Cohen versus California. That one is a little bit shorter. And ultimately, we'll read Atkins versus Virginia, which is a longer case. There have been judicial opinions that go well beyond 100 pages. And an opinion will be longer the more different justices write opinions. There may be just one opinion in a case, and all the other judges sign on to it. There could, however, be 9 different opinions. Each of the 9 judges could write separately. And we'll talk more about that in a few minutes. Okay, let's turn to some of the various components of a legal opinion, beginning with the caption. As Kerr points out, the excuse me, it's allergy season. And I may have a cold. I've been out riding my bike every day in the cold weather. The caption is simply the title of the case. Every case has a title so that we can refer to it efficiently. The caption consists of the names of the litigants or parties to the case. The word litigant comes from the word litigation. And I'm going to give you the dictionary definition of litigation. Litigation is, quote, the act, process, or practice of settling a dispute in a court of law. So if I say a particular court is very busy with litigation, that means it has a lot of cases before it. Okay? And we can refer to the parties as litigants. They're the ones who go into court because they have a conflict and they're trying to get a resolution of their conflict. We'll call them litigants, or simply the parties to the case. Now, the parties or litigants can be of different sorts. I'm going to give you some examples. There's a famous Supreme Court case called Bowers versus Hardwick, 1986. Bowers is the name of the Attorney General of Georgia at that time. He was a party, I think it was Michael Bowers. He was a party to the case. He was one of the two litigants. The other name is Hardwick. That was an individual. His name was Michael Hardwick. So here we have the Attorney General of the state of Georgia involved in a legal dispute with an individual, a citizen of the state of Georgia. Now, I don't need to go into the details of what that case was about, but I'm just giving some examples. Another case on the same topic is Lawrence versus Texas, Lawrence v. Texas. Lawrence is the name of an individual, once again. Texas, of course, is the name of a state. It's not the name of the Attorney General of Texas or anything like that. It's the name of the state. Sometimes states are parties to a case. Third, there's a famous case in tort law called Catco versus Briney. Catco was an individual and Briney was an individual. So you have two individuals who had a conflict. They went into court and the courts had to resolve it for them. You may have heard of the case of Roe v. Wade, Roe versus Wade. It's the famous abortion case from 1973. Roe is a pseudonym. It's a false name chosen by the court to keep the identity of the actual party or litigant confidential. We now know who it was. Jane Roe was actually Norma McCorvey, a Texas woman. But at the time of the case, her identity was not disclosed by the court. So it was just known as Roe v. Wade. Wade was the name of the district attorney of Dallas at the time, Henry Wade. So in general, the parties in a case can be of any of the following sorts. They can be human beings like you and me. Let's call them natural persons. I'm turning my page. You can do so as well if you're following along. At the top of page 2, you can see the second type of litigant is what we might call an artificial person as opposed to a natural person. Artificial people are legal constructs or legal fictions. The law treats as persons certain entities other than human beings. For example, business corporations. Microsoft is a business corporation. It's not a human being. It's run by human beings. It's organized by human beings. It's owned by human beings. But Microsoft is not itself a human being. Microsoft could be a party to a legal case, and I'm sure it has, probably many times. It's an artificial person. All corporations are persons, not natural persons, but artificial persons. Perhaps one day a non-human animal will be treated as a person for legal purposes. In other words, perhaps one day cows and pigs, gorillas or other primates, dogs and cats may be treated by the law as persons. Now, they will never be natural persons like you and me. They're not human beings. But the law may decide, for better or worse, to treat them as persons. They may have legal rights to sue, or even to be sued by others, to own property in their own names, to enter into contracts with others, that sort of thing. So one day we may have non-human animals who are treated in the law as persons, and they can become then litigants in cases. There may even be a day when artificial intelligences like robots, I'll call them robots, Robots may one day have legal rights. They may be treated as legal persons. We're not there yet, but we may be approaching that day. I put a footnote at the bottom of the page just to show you that I'm not making this up and I'm not trying to make a joke. There's a book from 3 or 4 years ago by David Gunkel entitled Robot Rights. It's a serious book about the rights of robots, about the rights that they may one day come to have, maybe the rights that some of them already have. It's a very interesting field. Law is constantly changing, as you know, and this might be an exciting area of the law for someone to take up. A new law student, a new lawyer, may try to get in on the ground level of this legal revolution. And maybe in 30 or 40 years, while you're still practicing law, there will be a well-established body of robot rights. And you can represent robots, either in suing others or being sued by others. Okay, so it's not a joke. There's already a movement to protect the legal rights of animals. In fact, the third reading in this course has to do with the legal rights of animals. And you'll see what I mean when we get there. Okay, so those are all artificial persons. The third of 4 possibilities is a governmental entity. Governmental entities are very common litigants in legal cases. The United States, the country, is a litigant in many cases that appear in the courts. A state like Texas or Arkansas or Wisconsin could be a litigant. A county within a state, the Tarrant County, for example, may have a conflict with a neighboring county, with Dallas County, over a stretch of land or a body of water or something like that. So there could be a case entitled Tarrant County versus Dallas County. Okay? Those are 2 governmental entities. There could be a city like Arlington. Arlington might have a lawsuit against a neighboring city, Grand Prairie, for example. There could even be a particular unit of government, such as a Board of Education. One of the most famous Supreme Court cases of all time is Brown versus Board of Education of Topeka, Kansas. It's the great desegregation case, 1954. So the Topeka Board of Education was a litigant in that case. Okay, so those are the litigants in a legal case, in a legal opinion. Let's now talk a little bit about some of the details or technicalities. Every case that is published has to have what's called a case citation. And the reason for this is we need to be able to tell people where to find it. Right? There are lots and lots of cases at every level of government, and there has to be an efficient system to locate them. If you go to a library, such as UTA's library, you'll see that there are shelf upon shelf of Supreme Court volumes, the United States reports, they're called. Now, you wouldn't want to go through hundreds of volumes looking for the one case you're trying to find, but what if you had the volume number in your hand, written down? What if you had the volume number of a particular set of books like U.S. reports, and you had the page on which that case begins? Well, it would take only a minute or so to find it. You would go into the library, you would stand up against the wall of books, you would find the particular volume you're looking for, such as volume 261. You would pull that volume down, and then going by the first page that you've written down, you could open it up, and there will be the case you're looking for on that page. So every legal opinion has a citation. I'm going to give you 2 examples in my lecture notes. The first is a case that appears in the U.S. reports, the United States reports. That's the official publication of the Supreme Court of the United States. It's published at government expense, which means ultimately the taxpayers pay for it. It's available to everyone, every citizen, for free. In fact, one of the wonderful things about the internet is that you can now find and read every Supreme Court opinion online. What a wonderful world. When I was in law school back in the late 70s and early 80s, new cases that were handed down by the Supreme Court came filtered into the law school weeks later. So if you heard about a decision the court had just handed down, all you could do is try to find a report of it in a local newspaper, or perhaps write to the court and ask for the court to send you a copy, and that would cost you money, or you could wait a few weeks until the library got a copy of it. I remember doing all of those things. Now, when a case is handed down, it's available instantly for you, me, and everyone else for free on the internet. Anyway, here would be an example of a citation to a Supreme Court opinion. 485 U.S. 759, and then in parentheses, 1993. Now, the first numeral, in this case 485, is the volume. That's volume 485. Yes, there are hundreds of volumes. The letters U.S. followed by periods stands for United States Reports. Okay, it's just an abbreviation. So that tells you which set of books to look in, because there's more than one set. The second numeral, in this case 759, refers to the page, the first page of that volume of the opinion. So the opinion in question starts on page 759 of that volume. It may go on for 10 pages, 20 pages, 100 pages, maybe more than 100 pages, but that's the first page. And that's all you need to find it. The part in parentheses, as you could probably guess, is the date that case was decided by the court, 1993. Okay, the second example is a state Supreme Court. Each state, including Texas, has its own Supreme Court. In fact, Texas has a two-tiered system. We have in Texas a Supreme Court, and we have a Texas Court of Criminal Appeals. So we have two hierarchies, one for civil cases, that one has at the top of it the Supreme Court, and one for criminal cases, that's the Texas Court of Criminal Appeals. Not every state does it that way. In my native state of Michigan, my home state, there's one Supreme Court that is the highest court for both civil and criminal cases. Okay, in my example, I have 171, Iowa 47, 1978. Same principles apply. It's volume 171 of the Iowa reports, and that's where they put their Supreme Court opinions, and I believe also they may put their appellate court opinions in that same set of books. The 47 refers to the first page of that opinion, and 1978 would be the year. Okay, so in this case, it's Iowa. If it were Massachusetts, you would probably have an abbreviation, MASS period. So you don't have to write out the whole word. But that would be enough to tell you that it's in the Massachusetts reports or reporter. Now, as you know, there's a court system at the federal level, and there are court systems in each state. And I've just been talking a little bit about Texas and Michigan and Iowa. The structure of the federal courts is as follows. There is a first tier level of what are called district courts. These are trial courts, federal trial courts, and they're scattered all over the country. A state like Texas has many federal trial courts. I'm sure there's one in Fort Worth, Dallas, Amarillo, Lubbock, probably Waco, Houston, San Antonio, El Paso, Tyler, many federal district courts. Now, those are trial courts. The party who loses may choose to appeal. If you appeal from a federal district court, you will be going into what's called a federal circuit court. These are lower level appellate courts. There are 13 of them in the United States, 13 different circuits, and they're numbered. The First Circuit, the Second Circuit, the Third Circuit, and so on. The third level of courts is above that intermediate appellate level, and that's the United States Supreme Court, or formerly the Supreme Court of the United States. So 3 levels: trial courts, they're called district courts; intermediate courts, those are appellate courts, they are where you appeal decisions made down below; and then the U.S. Supreme Court up above both of those layers. I posted an interesting map on Canvas just so that you can see the structure of our federal system. You can see that there are some of the states are bunched together with different colors. You see over here on this side, the yellow colored states, that's the Ninth Circuit. You can see the numeral 9 in here in the black circle. The Ninth Circuit Court of Appeals handles cases from quite a few states, doesn't it? Montana, Washington, Oregon, Idaho, California, Nevada, Arizona, also Alaska, Hawaii, Guam, and the Northern Mariana Islands. So any case arising from any of those states or territories will end up being appealed to the Ninth Circuit. Now, Texas, as you can see down here, is in the Fifth Circuit. I grew up in Michigan, right there, and Michigan is part of the Sixth Circuit. Chicago's in the Seventh Circuit, and so on. So this shows you the 13 circuit courts. There, you can see they're numbered 1 through 11, and then there's the DC Circuit, as it's called. It doesn't have a number, and the Federal Circuit. So 13 in total, but only the first 11 are numbered. There's been talk in recent years of breaking up the Ninth Circuit. It's so big physically, it contains so many states, and so many cases arise there. There's talk of dividing it up into 2 circuits, which would increase the number from 13 to 14. But I don't know what the status of that movement is, but there has been talk of splitting the Ninth Circuit for some time now. By the way, none of this is in the U.S. Constitution. Okay, this is all generated by legislation, congressional legislation. Congress can change any of this at any time because it created this whole system. The only court that's contemplated in the United States Constitution is the Supreme Court. Article 3 of the Constitution stipulates that there shall be a Supreme Court. It then adds, almost as an afterthought, and such other inferior courts as Congress may from time to time desire to create. So Congress has created the entire federal judiciary except the U.S. Supreme Court. Very interesting, isn't it? There's been talk recently, as you may have heard, of increasing the number of justices on the U.S. Supreme Court. Congress has the power to do that. The number of justices has been 9 for quite some time now, but it wasn't always 9, and it may not always be 9. So we'll see how that goes. Okay, so we're still on page 2. We've talked a bit now about the case citation. I point out a kind of oddity there. In the state of New York, the highest court in the state is known as the New York Court of Appeals. That's at the top of the hierarchy. There's also a Supreme Court of the state of New York. Now, the word supreme may suggest that that's the one at the top, but that's not the case at all. The Supreme Court of the state of New York is a trial court. So it's at the bottom. It has a branch in each of the state's 62 counties. So it's just one of the oddities of our legal system that some states, like New York, use the term supreme for something other than the highest court in the hierarchy. I'm sure everybody in New York has gotten used to that a long time ago. They don't even probably think it's odd anymore. Okay, the author of the opinion is usually listed by surname, comma, and then either J for judge or justice, sometimes by CJ. And you can probably guess what that stands for. If you see Roberts, comma, CJ, that means John Roberts, who is currently the Chief Justice of the United States Supreme Court. Okay, the Chief Justice has certain administrative responsibilities. The Chief Justice gets a vote in every case, just like every other justice, but the Chief Justice has certain prerogatives. The Chief Justice, as you will see, can sometimes dictate who writes the opinion. And the Chief Justice also administers the court system, which is and has a staff to help him or her do that. You may from time to time see the words per curiam. It's Latin. That's a Latin term, per curiam, and it means literally by the court. Sometimes the court as a whole will release an opinion, and when they say per curiam, they're telling the reader that the whole court decided this together. It's by the court. And there are no separate opinions by any individual judges. You could treat it as a 9-0 ruling, but no names are mentioned. It's just a ruling by the court. And typically these are fairly short. The court will dispose of some case by issuing a per curiam ruling. Okay, let's turn now to the facts of a case. And this is, believe it or not, one of the most important parts of any legal opinion, as Kerr points out. Every legal opinion tells the reader what happened, what gave rise to the controversy, what are the substantive facts, and what are the procedural facts. Two different types of fact. Let's take them one at a time. Substantive facts have to do with the substance of the case. Maybe somebody murdered someone and has been brought to trial. Okay, that would be part of the substantive facts of the case. Procedural facts have to do with how the case proceeded through the court system. So the procedural facts would include an arraignment on a criminal charge, for example, an indictment, a trial, a verdict in the trial, maybe an appeal from that verdict to a higher court. Maybe once the higher court issued a ruling, there would be another appeal to an even higher court, the U.S. Supreme Court, for example. So tracing the movement of the case through the legal system, that's called procedural facts. And so one of the things you're likely to see in any legal opinion is a recitation of the substantive facts of the case, what happened, who did what to whom, who took it into the court system, and why, and how, and where, and when, and then what happened once it got into the system. How did it move through? Those are the procedural facts. Now, two judges in the same case who write separate opinions in that case could emphasize different facts. And there's nothing wrong with that. Now, obviously, it would be a serious problem if any judge or justice ever misrepresented the facts of a case. Right? You must not do that. You must not misstate what happened. That's a no-no. But the facts are typically very rich, and two different judges can emphasize a different set of facts depending on their purposes. Here's my example. Suppose we have a case involving capital punishment. A judge who believes that capital punishment is constitutional, in other words, it doesn't violate the Constitution. An example would be Clarence Thomas, Justice Clarence Thomas. A judge who believes that capital punishment is constitutional may describe the murders in detail so as to make the punishment seem fitting. So Justice Thomas, very often in a capital punishment case, will describe in great gory detail what the defendant did, how the murder took place. Justice Thomas will say the defendant went into the convenience store, ordered the clerk to lie down, shot him 4 times in the back of the head, took the money from the till, and left. Now, do you really need to know how many shots were fired or in what part of the body? Strictly speaking, no. But it creates an image in the reader's head. The reader's thinking, that's horrible. What a brute. What an animal to do such a thing. And therefore, when you get to Justice Thomas's conclusion that capital punishment is appropriate in this case, it won't seem so it won't seem so crazy or off the wall, right? You'll be remembering the 4 shots in the back of the head. Now, a justice who disagrees with Justice Thomas, such as Stephen Breyer, who believes that capital punishment is unconstitutional, may ignore the details of the case and not talk about how many shots were fired, at what part of the body, and things like that. Okay, so 2 justices who come down differently on the constitutional question may choose to emphasize different facts when they recite the facts of the case. That's very common. And every litigant learns how to do that. It's one of the things you learn how to do in law school when you learn how to write a brief. Right? You need to make judicious use of the facts to help support your case. Never, ever misrepresent any facts. Right? If 4 bullets were fired, don't say there were 3 fired or 2. Right? That would be a misrepresentation. So you can ignore the fact that 4 bullets were fired. You could choose not to emphasize that, but you can't misstate it and say that 3 or some other number besides 4 were fired. Okay, so the facts of the case are very important. Kerr emphasizes that, and so am I. Right? When you read an opinion, pay attention to the facts, because sometimes the ruling will hinge on the facts. Little things that may not seem important can turn out to matter greatly in a legal case. A good litigant is someone who is aware of that. In fact, isn't that how detectives operate? Detectives are good at noticing little things that tie someone to a crime scene. Right? There used to be a weekly show when I was a kid called Columbo. Maybe you can find it in reruns. It's a terrific series. Columbo was a detective. He had a very unorthodox style. In fact, while he was investigating a case, he looked like a bumbling idiot. And yet, he noticed little things as he talked to people, as he visited the crime scene. He took note of little things. And the audience for the show would probably not even be aware of them. By the end of the show, that detective, Columbo, would put together all of those little things that he had discovered and make a case for why this particular person had committed the crime. And often he would surprise them and say, "You're under arrest." And the person in question would be surprised by it because he or she thought that he or she had committed the perfect crime. But Columbo outsmarted the defendant and noticed the little details. So just as detectives pay attention to details, so should lawyers and law students and readers of legal opinions. When you read the facts, pay attention to them. They matter. Some of them matter very much. Okay, the next item at the bottom of page 2 has to do with the law of the case. So after the judge in question or justice recites the facts, the judge will then state the law that's relevant to the case. Now, the law could be of any of a number of types. A constitution is the law of the land. The federal constitution, the United States Constitution, is the supreme law of the United States. Everything else at every level must conform to it, or it will be ruled unconstitutional by some court. Right? So the U.S. Constitution is the supreme law of the land. And anything that is inconsistent with it must not stand. It will be struck down as unconstitutional. Now, states have constitutions just as the federal government does. The state of Texas has a constitution, the state of Michigan, the state of California, the state of New York. And within each state, its own constitution is the supreme law of the land. So you have a hierarchy. Within each state, you have a supreme body of law, which is the constitution of that state. And in the federal system as a whole, you have the United States Constitution, which is the supreme law in the federal system and, of course, in every state as well. So no state constitution could ever conflict with the U.S. Constitution, right? The hierarchy says that the U.S. Constitution is supreme over the state constitution. Now, that's one source of law. Sometimes courts discuss constitutions when they resolve cases. The next type of law that comes into play is what's called a statute. Not a statue, like a statue of George Washington, a statute. It's got a T in it, an extra T, statute. The federal government has statutes, as does each state. A statute is simply an enacted law. So whenever the Texas legislature enacts a bill into law and it's signed by the governor and becomes a law, that now becomes part of the statutory law of the state. And it's published in bound volumes. It's also now available on the internet. Okay, so statutes are very often the main type of law that is used by judges to resolve cases. Sometimes the case is about a treaty. Now, treaties can be entered into only by the federal government. No state can enter into a treaty with another country. So Texas can't enter into a treaty with Mexico, but the United States can and has, and I'm sure will in the future. So if there's a treaty in effect, it can become a source of law. There may be a dispute between the United States and Mexico about the water in the Rio Grande. Or perhaps the Rio Grande has been carving a new channel into what was once Mexico. The U.S. may claim that the land that has now been separated by the river, that land belongs to the United States. And Mexico may say, no, it doesn't. That case could end up in court, and it may be decided on the basis of some treaty that the U.S. and Mexico have entered into. Sometimes states enter into the equivalent of a treaty with each other. They're called interstate compacts. So suppose Arizona and New Mexico have an interstate compact to share the water of the Colorado River. Both states are arid, they need water, and they may have reached an agreement to divide up a certain body of water or reservoir or river. They may find themselves in a dispute and go into court to get resolution. The court may look at the interstate compact that they entered into. It's a form of contract between states, and the court may be able to resolve the conflict by reading the compact and applying it to the facts of the case. There are also administrative regulations. These are issued by the executive branch of government at the federal level or even at the state level. Regulations are designed to fill out and implement statutes. These are called administrative regulations. Remember, the President of the United States, the governor of a state, they're executives. Their job, or at least part of the job, is to execute the law. That's why they're called executives. Their job is to administer the law, to carry it out. And they do so by issuing executive orders and other types of regulation, which are published and they have the force of law. So there may be a body of regulations on what people can do with their property. The Congress long ago passed an Endangered Species Act, and that act gives to an agency of the federal government the power to issue regulations. And those regulations have the force of law because Congress delegated the authority for them to the appropriate executive branch or agency, such as the Department of the Interior. So those regulations might be the source of law used by a court to resolve a case. And finally, there are what are called precedents, previously decided cases in the jurisdiction in question. So suppose we have a case in the state of Texas. Two litigants are going at each other in court. The litigants each will cite previously decided cases in Texas in the hope that the judge will find them analogous, in other words, similar, and issue a ruling in his or her favor. Okay? So one thing law students are taught to do is to do research, to scour the body of previously decided cases in that jurisdiction, and which may go back hundreds of years, and try to find cases that are relevantly similar to the case in question in the hope that the court will follow the precedent and issue a similar ruling in your case. It's a very common form of legal argument. Right? Try to find supporting cases in your jurisdiction. And the same thing is done at the federal level, although there's no sophisticated body of federal common law, as it's called. There are statutes and there are previously decided cases, but it's not as rich and deep as it is at the state level. Okay, one more thing before we go on to page 3. Now, ideally, when a judge is resolving a legal case, the judge will keep an open mind. The judge is to go into each case with an open mind, and you are to listen to the arguments made by the litigants. You are to examine the facts. You are to do your own research. Now, the parties will point you in the right direction when they write their briefs. You can read the previously decided cases. You can read the statutes, Constitution if that's relevant, regulations if that's relevant. And once you've examined all of the relevant legal principles and rules, all of the materials, and applied them to the facts, you will reach a result, a decision, a judgment. That's how the process is supposed to work. Right? Keep an open mind, do your research, apply what you find to the facts, and render a judgment. Some judges are accused of doing things backward, so to speak. Some judges are accused of making up their mind first about who should win, and then doing research, enough research to support that judgment. And the judge would then write up an opinion where you have supporting documents or sources to support the ruling. Now that's considered disreputable. Some people call that result-oriented jurisprudence. And it's disreputable. A judge isn't supposed to make decisions that way. Right? That's closed-minded, where you make up your decision first and then make up a rationale for it. You're supposed to go the other way. Keep an open mind, do your research, see where the balance of supports are for one side or the other, and then issue your ruling in accordance with that. So keep that in mind. We'll come back to that concept later in the course, perhaps more than once, what's called result-oriented jurisprudence. Judges like to accuse each other of engaging in that. Okay, let's turn to page 3. We just have a few things to go. We're almost 1 hour in, so I'll try to keep my lectures below 1 hour and 15 minutes each, but sometimes they'll be closer to 1 hour. Okay, Kerr has a discussion of what he calls concurring and or dissenting opinions. So I want to make sure you understand what he's talking about. First of all, let's distinguish in general between the decision made by the judge, and the decision simply has to do with who wins and who loses. Okay, that's the decision. But notice, the decision itself doesn't tell you anything about why that party won or lost. Okay, so let's distinguish between the decision and the rationale for that decision. The rationale is the reasons for it, the set of reasons why that party won and that one lost. All right, so I have here a definition of a term with a definition from what's called Black's Law Dictionary. It's one of the most prominent law dictionaries. I still have my copy from 1979. It's the 5th edition. And here's the definition of the term ratio decidendi. Now, I may be mispronouncing that. It's a Latin term. Sometimes I get them right, sometimes I get them wrong. But that's how it's spelled. You can see it in my notes. R-A-T-I-O, ratio, and then D-E-C-I-D-E-N-D-I, decidendi or decidendi. And you can probably see in there, ratio is related to rationale, the word rationale, and decidendi is related to decision. So the ratio decidendi, if you will, of a decision, the ratio decidendi of a case is, quote, the ground or reason of decision, the point in the case which determines the judgment. Okay, so you should look for that. Learn how to look for that when you read a legal opinion. Not only, you don't want to just see who won, because that doesn't tell you much. Okay, Jones won and Smith lost. Big deal. Why did Jones win? What was the case about? What happened to take it into the court system? And how did Jones end up prevailing in the case? And you could always ask, should Jones have prevailed? Maybe the judge made a mistake and it'll be reversed on appeal. So you always need to look for the rationale for the judgment or decision, not just the decision all by itself. So with that distinction in mind between the decision and the rationale for the decision, let's look at some different types of opinion. There are 4 of them that I want to discuss with you. The majority opinion, concurring opinions, dissenting opinions, and what's called a plurality opinion. Now, some of these should be familiar to you already. You may have just heard them on discussion on television. There may be a discussion of a case that was just handed down, and the commentators on TV may be talking about the majority. The majority said this or that. Okay, so what is the majority opinion? Well, notice that in my notes, I have some quotations. I have a quotation from Kerr, which in my notes is yellow, and I have a quotation from Black's Law Dictionary, which in my notes is green. Let me begin with Kerr. Kerr says the majority opinion is the opinion, quote, joined by the majority of the judges on that court, unquote. Now, how many judges or justices are there on the U.S. Supreme Court? You should know this. It's just a basic matter of civics. 9. There are 9 justices. That number could change one day. Remember what I said earlier, but it's been 9 for a long time. What's a majority of 9? Well, it's 5. 5 or more would constitute a majority of 9. What if we had a court with 7 justices? Some states have a Supreme Court composed of 7 justices, not 9. Well, if there are 7, then a majority would be 4 or more. What if there were a court with 5 justices, and there's at least 1? I think Alaska has only 5. Well, excuse me, 3 justices would form the majority in a case like that. Okay, so majority means a majority opinion is an opinion signed by a majority of the total number of judges on that court. Now here is Black's Law Dictionary definition. The majority opinion is, quote, the opinion of an appellate court in which the majority of its members join. So that accords pretty well with what Kerr says, doesn't it? All right, those two definitions are pretty much the same. Now here's what I wrote. First of all, I want to tell you the practice for how opinions come to be written. Typically at the United States Supreme Court, and remember, different states may do things differently, but at the U.S. Supreme Court, the practice is the justices will, once they agree to hear a case, they will assign time for oral argument and the submission of briefs by the litigants. The justices will each read the briefs and attend the oral argument. While at oral argument, they will not only listen carefully to the arguments being made by the litigants, but they will sometimes ask questions of the attorneys. So at the end of that process, once the briefs have been submitted and read by the justices and the oral argument has been conducted, the judges will take a vote. The justices will meet in a room in private and they will vote. And I'm not sure how this is done. I've never been in the chambers when that's done, but it could be a simple matter of how many people vote for the plaintiff or the appellant, whatever they choose to call that particular party. And the justices will probably raise their hands, and the Chief Justice will look around and say, okay, I see 5 votes for the plaintiff or appellant, and how many vote for the defendant or the respondent, appellee it's sometimes called. And the other 4 justices may raise their hands. So that the case is 5-4. Right? The Chief Justice can see from the vote tally, it's a 5-4 case in favor of one of the parties and against the other one. Now the Chief Justice gets 1 vote, just like all the other ones. So who gets to write the majority opinion? Here's what I wrote in my notes. After the votes are tallied, the most senior justice in the majority assigns the opinion, with the Chief Justice assigning, regardless of seniority, if he or she is in the majority. Okay, suppose I'm the Chief Justice. We've taken a vote. Suppose it came out 5-4. If I, the Chief Justice, am part of the 5, then I get to decide who writes the opinion, the majority opinion. Now that's a pretty awesome power, isn't it? Because I may have my own reasons for picking one particular justice as opposed to someone else. I know how each justice reasons and writes, and I know the kind of jurisprudential outlook of each justice. I may want an opinion that decides the case narrowly on the narrowest possible grounds. And that may mean either writing the opinion myself or assigning it to someone whom I know will produce the kind of opinion I seek. All right? Now, what if I, the Chief Justice, find myself in the group of 4? I'm in the minority rather than in the majority. I have lost the power to assign the opinion. The most senior member of the group of 5, in other words, the justice who's been on the court the longest, gets to decide who writes the opinion. And he or she can choose to write the opinion himself or herself. So that's the practice, as I understand it, the practice by which opinions come to be assigned and written. So who authors the majority opinion depends on who the Chief Justice is and whether the Chief Justice was in the majority. Okay, so very often in the United States Supreme Court, there is a majority opinion. And that would be the opinion that has precedential value, because that's an opinion signed onto by more than half of the justices. Okay, next item. What's a concurring opinion? The word concur is Latin, comes from Latin words meaning run together with. Con means run together, and con means together with, and cur means run. Cursor, the cursor on your computer screen runs across the page. Cursive is writing that runs together, not like printing where the letters are separate. A cur is an old-fashioned name for a dog. Oh, look at that unkempt cur. A cur is a dog, a wild dog running around, a dirty, flea-ridden dog running about through the streets or neighborhood. So, concur, or as it's pronounced, concur, means run together with. So here's the definition from the New Oxford American Dictionary. It's not a legal dictionary, but here's what it says. Concur, which is used as a verb here, means be of the same opinion, agree. Here's what Black's Law Dictionary says. In the practice of appellate courts, a concurring opinion is one filed by one of the judges or justices in which he agrees, of course that means she as well, in which he agrees with the conclusions or the result of another opinion filed in the case, which may be either the opinion of the court or a dissenting opinion, though he states separately his views of the case or his reasons for so concurring. And I added at the end of this, a concurrence may or may not be accompanied by an opinion. So let me back up and explain it in my own words. Suppose a particular justice writes an opinion. Some other justice may like what that justice has written, may agree with it. Well, rather than writing your own opinion, that second justice will simply say, I concur. I agree with what you wrote. I'm going to sign my name to it. Okay, that would be an unsigned concurrence. I'm sorry, it's a signed concurrence, but you didn't write anything of your own. It is also possible to concur with someone and write separately. So I may say in a short opinion, I concur with Justice Kavanaugh, but I want to write separately just to clarify something or make an additional point. So notice, I'm concurring with another justice, in this case Kavanaugh, but I also wrote a little something of my own. It could be a lot. Maybe I wrote several pages. It doesn't have to be just a paragraph. So some concurrences are accompanied by opinions and some are not. That's the point I'm making. All right, so you see a lot of concurrences in judicial opinions or legal opinions. All right, next, what's a dissenting opinion? I'm sure you've heard of this. Sometimes, if there's a majority opinion, one or more other justices will disagree with it, and they may choose to write separately to set forth their reasons for disagreeing. Okay, here's the New Oxford American Dictionary definition of the term dissenting opinion. Of the term dissent. Dissent, used as a verb, means hold or express opinions that are at variance with those previously, commonly, or officially expressed. So notice, at variance with. Okay, that means you disagree with someone. And here's how Black's Law Dictionary puts it. The term dissent is most commonly used to denote the explicit disagreement of one or more judges of a court with the decision passed by the majority upon a case before them. In such event, the non-concurring judge is reported as dissenting. A dissent may or may not be accompanied by an opinion. So once again, as in the case of a concurring opinion, if I dissent from the majority ruling, I can do so either with or without an opinion of my own. Most dissents, I would suggest, do have opinions. What would be the value of me saying, suppose I'm Justice Burgess-Jackson. Justice Burgess-Jackson dissents. What would be the point of even putting that in there, right? If I don't state my reasons. So almost invariably, a dissenting justice will write an opinion setting forth the reasons for disagreeing with the majority. And sometimes these dissenting opinions can become heated and even, sadly, personal. The justices take little jabs at each other. They use innuendo. They try to embarrass each other. I may try to find a case. Suppose I'm a dissenting judge or justice, and one of the 5 members of the majority has previously, in some previous case, written something that seems to contradict what is being said today in this current case. I'm going to draw attention to that previous case and say, Justice Sotomayor, who's in the majority today, said just 10 years ago the following. And the purpose may be nothing more than to embarrass Justice Sotomayor, to try to make the reader think that she is flip-flopped, or that she is somehow inconsistent, or has forgotten what she decided just 10 years ago. So you get a lot of that jousting, and it makes for interesting reading sometimes. The personal differences between the judges, the little jabs and remarks. Okay, one more type of opinion. It's called a plurality opinion, and I'll just read the Black's Law Dictionary definition. It's an opinion of an appellate court in which more justices join than in any concurring opinion, though not a majority of the court. That is a plurality opinion as distinguished from a majority opinion in which a larger number of the justices on the panel join than not. Now, here's an example. Suppose the 9 members of the Supreme Court are fractured. We've got a group of 3 who rule for the plaintiff, okay? And we've got a separate group of 2 who also rule for the plaintiff, but they write separately because while they reached the same decision, they did so for an entirely different reason. So we've got 5 people who agree on the outcome, but they do not agree on the rationale. So it's not a majority. There's no majority opinion. Now, the other 4, let's assume, are dissenting. So here we have a case where it's a 5-4 case. The plaintiff wins because 5 votes is greater than 4, but there's no majority opinion because the 5 in the majority, if you will, could not agree on the rationale, the reason for why the plaintiff should win. So what we have here, the group of 3 would be called the plurality. The group of 3 who wrote together would be called the plurality opinion. Their opinion would be called the plurality opinion. It's not a majority opinion. You may be wondering what would be the significance of that. Well, the 3-member plurality, that plurality opinion would have no precedential value in future cases because it's not a majority. It might have some persuasive value. In other words, the reasoning of those 3 justices may be so cogent, so sound, that in future cases it will be used, it will be cited as authoritative. Not because it's a majority opinion, but because the reasoning is so impressive. Okay, so sometimes plurality opinions end up changing the law, not because they are a precedent that must be followed, but because the reasoning is cogent. Okay, finally, a couple more things at the top of page 4, and we'll be done for the day. Remember now, in the United States Supreme Court, there are 9 justices. So assuming that all 9 of them participate in a given case, what are the possible outcomes? Well, it could be a 9-0 outcome where all 9 justices agree. That's not as rare as you might think. There were quite a few 9-0 rulings this past year, in fact. The case could come out 8-1. There was a case just today in which 8 justices agreed with the ruling and 1 justice, Justice Thomas, dissented. 8-1. The case could be 7-2. It could be, I think Roe v. Wade was a 7-2 case. It could be 6-3 or 5-4. So there are what? 5 different outcomes, assuming all 9 justices participate. 9-0, 8-1, 7-2, 6-3, 5-4. Any one of them would, if 5 or more justices wrote the majority opinion, would be binding, have binding precedential value. Now, obviously, a 5-4 case is more likely to be overruled at some point in the future than a 9-0 case. Brown versus Board of Education, decided back in 1954, was 9-0. And I think the story is that the Chief Justice, Earl Warren, twisted the arms of the justices who were inclined to dissent and said, look, this is a case that's of great importance to the nation. And if even one person dissents, making it an 8-1 case, there will be people in the country who refuse to abide by it. They'll say, look, even the Supreme Court justices were divided. So Justice Warren said it's important that we put on a united front and 9-0 so that the people in the country look at it and say, wow, the justices who often disagree with one another don't disagree at all. They believe that racial segregation in public schools is a violation of the Constitution. So that turned out to be a 9-0 case. Okay, I compiled a list of Supreme Court justices for you. This is strictly speaking not a matter of philosophy or philosophy of law, but I thought it would be of interest to you anyway. Think of it as part of your civic education. The current justices of the United States Supreme Court, in the order in which they were put on the court, are Clarence Thomas, Stephen G. Breyer, John G. Roberts Jr., who happens to be the Chief Justice, Samuel A. Alito Jr., Sonia Sotomayor, Elena Kagan, Neil M. Gorsuch, Brett M. Kavanaugh, and most recently, Amy Coney Barrett. I put in parentheses the president who nominated each of these 9 justices and when the date on which they were seated on the bench, and also the law school from which each graduated. You may find it interesting that there are 4 Yale graduates, Yale Law School, 4 Harvard graduates, and 1 Notre Dame graduate, Amy Coney Barrett. So you could think of her as the tiebreaker. It's Yale against Harvard. And all 8 of those, by the way, are Ivy League schools. Justice Amy Coney Barrett replaced Ruth Bader Ginsburg, who died a couple of years ago. Ruth Bader Ginsburg was also an Ivy League law school graduate. She attended Columbia University and Harvard both. I can't remember which one she got her degree from, but she started off at one, finished at the other one. They're both Ivy League, though. So until a couple of years ago, a year and a half ago, all 9 justices were from the Ivy League. It makes you wonder whether we have a diversity of justices on our court. And I'm not talking about racial diversity or sexual diversity or anything like that. Are these justices drawn from all over the country, from different walks of life? Did they have different experiences? Were they educated in different types of university? It makes you wonder if all of them came out of the same Ivy League law schools. They look like peas in a pod. They may be all members of the same social class and so forth. So I can see a basis for a critique there. Notice also, since I put the president in parentheses, 6 of the current justices were nominated by Republican presidents, 3 by Democrat or Democratic presidents. So that's the current makeup of the court. You may be wondering, why is John Roberts the Chief Justice? Well, the Chief Justice is a particular line of the court. One of the 9 lines is always the Chief Justice. So until John Roberts dies or retires or is removed from office, he will be the Chief Justice. He will be not only a justice, he will be the Chief Justice. If and when he, well, not if, but when he eventually steps down or dies in office, he will be replaced not only as a justice, but as a Chief Justice. So suppose, just for the sake of discussion, suppose Chief Justice Roberts resigned today. Okay, it could happen. Who would replace him? Well, the current president, Joe Biden, would replace Chief Justice Roberts with a new Chief Justice. Joe Biden, President Biden, could take one of the other 8 justices currently on the court and elevate that person to be Chief Justice. So Elena Kagan, for example, who's fairly young, younger than Justices Sotomayor or Breyer. Elena Kagan, who was nominated by Barack Obama. Remember, Joe Biden was Barack Obama's vice president for 8 years. So Joe Biden might replace John Roberts with Elena Kagan, and it would be Chief Justice Kagan for as long as she lives, right? Which could be 30 more years. So that's how it works. When the current Chief Justice steps down or dies, the president at that time will name the next Chief Justice. Okay, let's pick up on Tuesday next week with the section entitled Common Legal Terms Found in Opinions. I'm going to try to finish the article on Tuesday. I think we can do it. We covered 3 of the 6 pages today. We're roughly halfway through my lecture notes. So I went a little bit long today, an hour and 22 minutes. Some days it'll be shorter. It'll average out, I think. So have a great day and a great weekend. And I'll look for me. I'll get my video posted probably Tuesday next week. And I'll always send an email as soon as it's posted. See you then.